Not sure if a computer reboot was able to take care of it, or if a recent computer update may have removed some priority authorizations for the streamer. Either way, I think there's definitely going to have to be some work done this week. It's a perfect week to throw this on me, as we've got the legislature in full-blown session with bill deadlines by Friday. More than 70 bills passed in the House yesterday, and both the House and Senate are going to be in today. It's high-flying action. The governor's got an event. He's going to be doing several things, so we'll have a lot to say about all of that. But here with Illinois in Focus Daily, you can wake up with us each and every weekday morning. Yesterday was a little bit glitchy for the live show. So I just want to remind everybody, we do the podcast live to tape, so later on in the morning you can catch the entirety of the program without interruption, and then you can also get segments of the show at the Center Square's YouTube page. So be sure to check all of that out. I really do appreciate those who are still with the live stream, even with the glitches. I think it really shows the true supporters of the program. So we tried going live already this morning, and then coming back after trying to reprioritize the streaming software. So maybe we'll have to do some more engineering. Anyways, it's got to get to the business at hand. We're going to talk about several bills that passed the House yesterday and the Senate on Friday. But we also got to talk about litigation in the courts. Everything from the sanctuary states policies being challenged in federal court to the state's gun ban being challenged in federal courts, and the latest on both of those. So stay tuned. We'll get to that next here with Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning as we bring you Illinois in Focus Daily, right here with YouTube and the Center Square. Be it ordered that the case challenging Illinois' gun ban moving forward in the 7th Circuit U.S. Court of Appeals after the plaintiff said they're sitting in purgatory right now. Welcome back. It's Illinois in Focus Daily. I'm Greg Bishop. Wake up with us each and every weekday morning here on YouTube for the Center Square. Get the newsletter in your inbox at thecentersquare.com. And if you do get that newsletter in your inbox, you'll find a whole bunch of headlines. But if you follow me on X, Bishop on Air, you'll be able to find some of the latest that's going on, including yesterday, as we saw the Illinois State Rifle Association, just one of several plaintiffs groups, announced that they asked the federal appeals courts to move on with the case, give them a briefing schedule so that the plaintiffs are no longer in purgatory. And the appeals court on Monday morning, after that filing Friday by the plaintiffs, said, hey, here's the schedule. All right, so let's get into this. So January 2023, the state of Illinois enacted a ban on more than 170 semi-automatic firearms, magazines over certain capacities. And that included a registry where you had to register firearms that you owned before the ban in order to be above the law. And if you didn't do that, there could be some criminal penalties, and multiple criminal penalties for items like, if you have magazines and such. So clearly this was pretty controversial, pretty contentious. The measure that passed by gutting a bill and replacing it with different language. And that gut and replace happened during a lame duck session in January 2023, and the governor signing that. And then the courts were asked to get involved. You had state challenges filed by the likes of attorney Thomas DeVore. He had thousands of clients with temporary restraining orders against the state, and those lasted for months. But then in federal court, you had plaintiffs across the states locally challenge things like Naperville's gun ban in November of 2022 with the Beavis case. They then included the Illinois ban after it was passed in January 2023. That case is still pending in district courts, in federal district court. You've got challenges to Chicago and Cook County's ban as well, and the state ban that are pending in court as well. But all eyes seem to be on the 4 cases consolidated in the Southern District of Illinois, where you've got the challenge of the gun ban having been dealt with on the merits. So if you remember in 2023, a lot of the action in court was on preliminary grounds. You had requests that there be a preliminary injunction, which essentially means an initial hold of the law while the case is being dealt with on the merits. And this is a typical process that plaintiffs' attorneys will do to try to get immediate relief while they deal with the long and arduous process of having to essentially deal with the merits, which those preliminary requests in 2023 went all the way up to the appeals court and even attempts to go to the U.S. Supreme Court, but that didn't seem to help at all. You had the U.S. Supreme Court essentially say that they were going to not take any cases that weren't ripe, that weren't ready to go. Then it was back to the district court for the merits of the case, and they took those merits up on last year with a 4-day bench trial. And Judge Stephen McGlynn in the district court, he ruled that the law was unconstitutional. And he said, ultimately, those who are being hurt here are being hurt by their rights being infringed upon. So we covered all of that, right? And then the state appealed, and the appeals court took the case. There was some back and forth with the issue of, was McGlynn's order fully, entered? They needed some clarity or something to that effect. And I do have to again apologize to those who are watching this live. The encoder is dropping, even though it looks like I've got a strong signal going out for uploads. So I appreciate you guys being patient with me. But if you can't take the live show dropping here on YouTube, you'll be able to check out the segments, I promise, or get the podcast. So anyways, the appeals court took the case from the state appealing, and McGlynn's stay on his order that the law was unconstitutional, a permanent injunction against the law saying it was unconstitutional, he held that with a stay. A stay is essentially saying my order is not going to go into effect pending appeal. So the appeals courts then continued that stay in December. Here we are now, April 8th. Where's the finality on this? We had no updates in the appeals court. We've talked about it, right? People have been asking me, what's the update? What's the update? The update was that there was no update from the appeals court as to a briefing schedule. Well, the Illinois State Rifle Association and the other plaintiffs groups in the Southern Districts, they wrote to the appeals court and said, hey, we need to get moving on this. Here is Ed Sullivan, Illinois State Rifle Association's lobbyist at the Capitol yesterday. He says Friday they put that request into the appeals court.
So Illinois State Rifle Association asked and put out a statement and a request through the courts that we get moving on our so-called assault weapons case, and amazingly we got a reply today. So we put this request out mainly because we believe that the Attorney General and the state has been dragging their feet, and we believe they've been doing it for one specific purpose. We need to have this court case to go through the courts to get to the U.S. Supreme Court for a potential to be heard by October. The more they drag that out, the less likely it is that the U.S. Supreme Court would take up this ruling, or this whatever ruling takes place, should it go against us, which we expect. And so today we did receive notice that the hearings will take place. So the state must reply by May 7th with their case. And then we, as the appellee, all the cases that are before them, before the Seventh Circuit, then have till June 6th to reply, or to send in our notes. And then the state then gets to reply to our notes at the end of June 27th. And so at this point, hopefully we'll have all that through by the end of June and can get some resolution in time to go to the U.S. Supreme Court should we lose at the Seventh Circuit. Which,
so the U.S. Supreme Court issue is obviously something they've been eyeing. When we talked to Sullivan before in the past, he had postulated it's possible this could be a 2026 case. Could it still happen this term? Sure, but that's only if the appeals court actually takes up the case and hears it on the merits after the briefing schedule, which, as you see, the briefing schedule lasts all throughout June 27th. So now they're going to have this briefing schedule and then have oral arguments. How long is that going to take? Who knows? It probably is not going to happen this year. I'm just speculating here. But you heard Sullivan there say that, hey, he anticipates that there's going to be a ruling in favor of the state from the appeals court in this case. I asked him why, because it's a different 3-judge panel than the 3-judge panel that handled which split, by the way, that handled the preliminary appeal, the preliminary injunction from the district court last year, or the year before last, I should say. Again, this is highlighting why people are frustrated because it's taking so long. This law was enacted in 2023, and here we are in April of 2025. So I asked Sullivan, why does he think that the appeals court's going to rule against them?
So we just have always believed, and if you look throughout the country, that all this is eventually going to make it to the U.S. Supreme Court. Probably where it needs to be. We would love to have a decision. Don't get me wrong. Don't take that the wrong way. But we believe all the cases will eventually make it to the U.S. Supreme Court. And then let's have finality. And we believe we will at the U.S. Supreme Court.
Now, in all of this, 2+ years, we're still standing by waiting for some finality. People on comment boards say a right delayed is a right denied. People saying that they're in purgatory, waiting for some kind of finality. Even after the district court said this was unconstitutional, you've got the law still in place. What are people supposed to think about that?
Well, from our perspective, just because we've seen this in motion and we've been kind of at the front and center of it with all the other appellants, that this is a delay tactic, and something had to be done. We were trying to get moving. We were trying to do things that, the legal way, if you will. And so, finally they forced our hand. And so we had to do something to move this along in light of the deadline that we're seeing for anything to go to the U.S. Supreme Court. And so, we rolled the dice, it worked, and that's what we're here to do. We're here to move things forward for our constituents, for our people that believe in the Second Amendment.
And what does ultimately that all mean? It means it's still going to be a bit, right? We got until June 27th for the final day to have stuff filed to the appeals court. But here we've got, the district judge, Stephen McGlynn, with a pretty thorough ruling after a 4-day bench trial dealing with the difference between military-style firearms and firearms that are commonly available to citizens, everything from the metallurgy that's used in the barrels to the stress tests that are done to the difference between semi-automatic and full auto or burst. It was pretty intensive as to all that they talked about during the district court hearings, and the district judge said, well, it looks like this law is unconstitutional. The impact of McGlynn's order, Sullivan says, is important.
I think McGlynn did an outstanding job. I think he did an outstanding job on making sure that he put forth the arguments that are going to align with Bruin, align with, the laws of the land, and align with what we are hearing out of the U.S. Supreme Court and what we think they're going to do and take up as arguments. And so I think it was just a masterful job.
We'll keep you updated as to the latest there here with Illinois in Focus Daily. And again, if you follow us on the website or me on X, you got the latest yesterday as it was coming together. So I encourage you, if you want to stay up to date with all of that, get the newsletter in your inbox with the Center Square, or just visit thecentersquare.com. We're a free newswire service hooking you up with the latest you need to know here in Illinois and beyond. I'm Greg Bishop for Illinois in Focus Daily. Catch us live each and every weekday morning. Even if it's kind of glitchy, don't worry. We record stuff locally so you can catch it on replay and on the podcast. So subscribe now and get those segments and clips and all kinds of stuff with Illinois in Focus Daily and the Center Square. Illinois sanctuary state laws continue on in federal courts, with Governor J.B. Pritzker laying out what he has to say in response to the U.S. Department of Justice saying, hey, your sanctuary policies violate federal law and is unconstitutional. Welcome back to Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and join us each and every weekday morning. So right after Pam Bondi became the U.S. Attorney General, she went and ultimately sued the state of Illinois over the state's sanctuary state policies. And those policies say police cannot communicate with federal law enforcement officials when it comes to immigration enforcement. Illinois has laws like that. Cook County has it. Chicago has it. So Pam Bondi sued the state of Illinois, Cook County, and Chicago. And the defendants here, the state of Illinois and these other governments, they made a motion to have the case dismissed from federal court, saying that they don't feel that it is unconstitutional to not use state resources for federal immigration law. Then the U.S. Department of Justice, as we were first to report here with the Center Square, filed their response, essentially pushing back on all of what the state said is why the case should be dismissed. Well, now we have a new filing here from the state, defendants' combined response to the United States motion to set the briefing schedule for its anticipated cross motion for summary judgment. So it's 5 pages long, and essentially what it spells out is J.B. Pritzker in his official capacity as governor, as well as Chicago mayor, the superintendent of Chicago police, Cook County and the county board commissioner, and the sheriff. They moved to dismiss the complaints, and the United States responded in opposition. The United States would also like to file a cross motion for summary judgment. Despite multiple requests, however, they say the United States refuses to answer the basic question of whether such a motion would rest on evidentiary materials not presently in the record. The communicative stance by the United States poses a problem for obvious reasons if the United States intends to move for summary judgment solely on the basis of memorandum it filed in opposition to the defendant's motion to dismiss, without submitting declarations or relying on other factual materials. Then defendants agree that it makes sense to brief the United States cross motion at an earlier junction in the case and concurrently with the various motions to dismiss. So it goes on there, and we're going to see a lot of this procedural wrangling in this case, and it's one reason why it's probably going to take a while for the challenge against Illinois' sanctuary state policies to actually advance and to have some finality. Maybe it won't even happen before the Trump administration finishes out its term. But you've also got amicus briefs that have been filed in this case. This coming from the Illinois Coalition for Immigrant and Refugee Rights, and they filed this 17-page document, and they obviously are siding with the state here, and they say through this lawsuit, the United States seeks to results that would unleash devastating consequences throughout Illinois. The U.S. government's requests that this court invalidate city, county, and state laws that prevent local police from engaging in immigration enforcement referred to throughout this brief as sanctuary laws. The local government defendants correctly argue the U.S. government's attempt to commandeer local law enforcement violates U.S. Constitution, but the relief request here isn't just unconstitutional. If this court accepts the U.S. government's legal position and requires local public safety officials to enforce federal immigration laws, immigrant communities will be forced into an impossible catch-22. People will risk deportation every time they seek medical care, enroll their children in school, shop for groceries, or report unlawful employment practices. As a result, the risk of public health crises will increase exponentially. Public education will be undermined, local economies will crumble, and employers who violate wage and hour laws and abuse their employees will escape accountability. So that is what the advocates for immigrant populations in Illinois essentially have to say in their opening to their amicus brief. This story will continue, and it's something that maybe the governor will be asked about this. He's got an event today in Springfield at the governor's mansion. So we'll try to get there and ask the governor his thoughts on the status of this sanctuary law challenge from the U.S. Department of Justice and why we need to have sanctuary laws. Is it as simple as saying that, hey, an immigrant community member can't go to law enforcement and say, hey, I've been a victim because, well, if they ask my immigration status and I say that I am not a citizen, are they going to have to report it to local law enforcement? But on the other side, you've got sheriffs saying they've got illegal aliens in their jail that they can't tell ICE about. So this is the argument, both sides of it. How this is going to be handled by the federal courts, we'll keep watching. But those are the latest filings in that case against Illinois' sanctuary state laws, and where this will end up, we'll be watching. It's right here, Illinois in Focus Daily. I'm Greg Bishop. Get the podcast where you get podcasts. Watch the live show weekday mornings Been having a few blips and blurps. It just so happens to happen in the busiest week in months whenever they've got both the chambers of the State House in session. So who knows? We'll get that figured out, and that way the live show won't be all glitchy. But hey, the podcast is live to tape, so you get that uninterrupted. The segments we record live to tape, and that's why you should just go ahead and like, subscribe, and hit that notification bell with Illinois in Focus here on YouTube with the Center Square, and get the headlines in your inbox at thecentersquare.com. The Illinois House passed more than 70 bills yesterday. And I anticipate they're going to pass hundreds more out of both chambers before the end of the week. Good morning. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Wake up with us each and every weekday morning with Illinois in Focus. Get the segments here on the YouTube channel, and you can get podcast full, uninterrupted, live to tape each and every weekday morning. Just search for Illinois in Focus. And don't forget to get the headlines in your inbox, where you can go check out some of the latest that surfaced to the top, including bill passed to allow the abortion pill even if it's deemed unsafe by the FDA. That passed the House yesterday. We'll touch on that. We've also got price gouging as a concern amongst members of the Senate, so we'll touch on that as well. But those are just some of the headlines you'll get at thecentersquare.com, and you can also check out the headlines on the national page. But get the newsletter. It's real simple. Just sign up. It's free. So let's get into the State House here. All right, I'm a associate editor for Illinois, and I've been tracking what happens at the State House every year for 11 years now. And here we go with the 104th General Assembly. And go to the website ilga.gov, and this is how you can kind of follow along. So just to see how many bills they passed and what bills passed yesterday, you could either do what I get paid to do, to sit there for the 7 hours of session that they had. I didn't get out of there last night until 8:30, 8:45. And then you have, committees that met afterwards. Several of my colleagues had to stay up even later. But they're back at it this morning, all right? Just the House was in yesterday. The House and Senate are in today. But go to ilga.gov. Scroll down. It's probably one of my favorite areas, reports and inquiries. Let's go to legislative reports. And then you go to the date inquiry and make it yesterday, so the 7th. And then you go to bills passed the House. Shazam, you will see that they passed, scroll down all the way to the bottom, 71 bills yesterday. They passed 71 bills out of the House. Now, Friday, out of the Senate, they passed about a dozen bills, and one of them dealt with the issue of price gouging. So here is a state senator talking about her bill to essentially, well, let me see here. Let's do the price gouging after we hear. Oh, no, it's right here. Okay, here's State Senator Glowiak Hilton talking about price gouging and how if there's an emergency declared by the government, then you can't increase prices more than 20%, or else you can have the Attorney General crack down on you.
It's become a cottage industry that people come in during disasters into a disaster area and start jacking up prices on diapers and water and all kinds of things that people need. It just amends the existing Consumer Fraud and Deceptive Practices Act. So the AG's office could already go after people, but this makes it a little clearer about the percentage and the number of days afterwards. So this is, when folks are the most vulnerable after a disaster, when their house is ruined or there's, the house is flooded or whatever.
Yeah, and you can't afford things. If it's going to be price gouging going on. State Senator Jason Plummer said this may be well-intentioned, but he worries that this piece of legislation could turn into a disaster.
We're going to insert the Attorney General's office in a new way in the middle of commerce, and it's going to impact the good guys. Because the bad guys are going to be long gone, right? This is going to impact the good guys. It's just more burdensome. And 20% is not a huge number. If you look at any market, if you look at any business model, 20% swings in insurance, 20% swings in commodity products, 20% swings in all kinds of things happen regularly. And you're going to turn the Attorney General's office and who knows who else loose on small businesses and medium businesses around the state. it's well intended, but this is going to be a disaster for the people who are trying to provide goods and services in all of our districts. And it's going to create a litigation nightmare for them.
And how that's going to play out, this is just a measure in the Senate. It passed. It's got to get into the House, where surely there's going to be more debate. So on Friday also, the Senate passed another measure about allowing nonprofit organizations to pool their money together to invest and then take those returns on investments and put it back towards their nonprofit. But the Illinois treasurer would be involved with this somehow. Here is Senator Johnson talking about her measure.
A prudent way to do this is by investing a portion of the nonprofit's cash in investment vehicles, like a nonprofit investment pool. Senate Bill 246 amends the State Treasurer Act to allow the State Treasurer's Office to establish a nonprofit investment pool and electronic payment processing program options for 501c organizations. Senate Bill 246 clarifies that nonprofit organizations registered as a 501c3 and 501c5 may participate in the investment pool and electronic payment processing program. Senate Bill 246 would also require nonprofit organizations to provide the Treasurer's Office with a copy of their most recent audited financial statements or charitable organizations' annual reports filed with the Illinois Attorney General's Office.
So Johnson talking about the measure, essentially saying that the treasurer would be involved in this, and people had problems with this. They had concerns about this. State Senator Steve McClure said, hey, this could actually break bad.
I have a concern with the fact that this still leaves other political-leaning nonprofits and gives them the ability to participate in this. Is there any way that you'd be willing to ensure that this is all free from politics as far as these nonprofits are concerned?
I like to think that nonprofit organizations that have specific missions, I started off by talking about the fiduciary responsibilities, investments, they also have a responsibility to stay true to their mission. And from what I'm understanding you're saying, if these nonprofit organizations have a political pack, I like to think they're going to keep it separate because they're going to stay laser focused on their missions.
The issue here is that this will be the law, and my concern is that you're going to see groups be excluded because of politics. You may see not-for-profits invest in this fund to get their money in the pool to try to curry favor with a future treasurer. Those are real concerns.
So, yeah, you can see how if there are nonprofit groups that are political, are they going to try to curry favor from the treasurer by investing their voluntarily donated dollars to this investment pool? Sometimes these nonprofits do get some kind of tax dollars as well. How's that going to be managed? So interesting to hear that piece of legislation go through the Senate. That was Friday. Yesterday at the House, they passed again 71 different bills, stuff on, recognizing certain holidays, not as official state holidays, just commemorative holidays, to dealing with a variety of other things, education policy. There was measures to allow for tax dollars to be used for teacher grants and things like that. Even the question of subject to appropriation when it comes to some of these initiatives legislators have, they just put a line in there subject to appropriation and then it never gets appropriated. So they work all this time to pass a bill that has this new policy, this new program, but then they put subject to appropriation and it never gets appropriated. So there's that happening as well. But one measure that was pretty contentious yesterday dealt with what are called shield laws. This essentially would say that if somebody is in state A, where they banned abortion, but they, do the procedure, right? They execute the procedure, and their license in that state gets taken away. They can come to Illinois and practice as long as what they had their license taken away in another state is legal in Illinois. So it's like a shield law. It went further as well to say, well, essentially, certain medications or drugs that are found to be not safe by the FDA, if it's found safe by a global organization, then it's okay in Illinois. Here's the back and forth. State Representative Dagmara Avalar with her measure about shield laws.
One of the things that we wanted to make sure is that we were being proactive, and we know that currently at the federal level there are multiple entities that are being weakened, for the lack of a better word. So we want to make sure that when it comes to this particular issue, that FDA approval for medication abortion would not be something, or actually if the FDA were to take this medication out of its FDA approval, that it would not still ban or limit access to medication abortion in Illinois. What I would say is that FDA approval for medication abortion, if the FDA revokes that, we would still in Illinois be able to have these drugs from being able to be prescribed in the state.
Now, State Representative Bill Howder, Republican, he is an emergency room physician and anesthesiologist. He says that this whole thing is absurd and says that to think the state of Illinois would allow something that the FDA does not approve of is unthinkable.
Mr. Speaker, this is outrageous. We are saying that approval of a drug by the World Health Organization, but active rejection because of safety by the U.S. Federal Drug Administration would be able to be prescribed in Illinois. We have to stop this fort of breaking down all of the safety mechanisms we have around abortion. There has to be some safety mechanisms, whether it be in the abortion clinic or it be with abortion medications. Do not reject the authority of the U.S. Federal Drug Administration. This is an important safety mechanism. This bill would reject that. I don't know if this is unprecedented in my mind.
So measure passed regardless of the opposition there. And again, the House passed 71 bills Monday. Both the House and the Senate are back in today. We're going to have some just rapid fire bills going out. We'll be back tomorrow morning to keep you updated on that. Here with Illinois in Focus Daily, I'm Greg Bishop. Like, subscribe, hit that notification bell, get the podcast where you get podcasts, and don't forget to get the newsletter in your inbox every weekday morning here with the Center Square. All right. As I said, the live show is live to tape to podcasts. We do the live video. I have some engineering I have to do. Don't know if a computer updates on my streaming computer. Switched some priorities, so I'll have to get that taken care of to make sure the live video show doesn't get all glitchy as people check that out. If you are watching the live show and you stuck through it, thank you. But again, get the podcast where you get podcasts, Illinois in Focus. Get the segments of the show. The video segments will be ready later this morning. So be sure to check that out and get what you need to know here with Illinois in Focus Daily. I'm Greg Bishop. Have a great day, guys. We'll be back Wednesday morning.